Our next speaker that we have, her and I met actually once upon a time. I run an investor group. So you guys, anyone who doesn't know me, I run an investor group. We meet the third Wednesday of every month. I know Maria's been to it. And through our property manager, I was introduced to Heather. And she actually spoke at my investor group, and I referred a ton of business to her. She's one of those realtors. She's one of those attorneys who speaks in layman's terms, which I love because no one likes when someone speaks over their head, right? Heather's been really great in getting some of my clients' earnest money back. And with very little effort. All it is a little letter that comes from an attorney's office, and it's like, boom, here comes the money. So that's really awesome. She's helped a couple clients with some other things that, and a lot of times it's with no effort. It's just with a skill that she has of knowing what to do to get people to, and people are afraid of lawyers. So, they see a lawyer involved, they're like, we better do it, anyway. So Heather, she's a business law attorney, real estate attorney. She does trust. She knows a lot about trust. She's helped my parents out, which is great. She doesn't just set up a living trust. She does the whole package, which I'm so helpful. I'm so grateful because my parents are older now, and she set them up with POAs. So I have power of attorney on medical and health before I ever needed it. And now it's coming into play where I'm having to use that. Well, Heather's been a corporate counsel to homeowner associations, municipalities, residential developers, land development firms, technology pioneers, research organizations, contractors, restaurants, retail services, and a multitude of other professions and businesses. She is a business lawyer who provides legal advice for anyone wanting to take their business or organization to the next level. She also has set up my LLC. She does all that. She does the whole package there too. So if you haven't set up your business license in your LLC, this would be who you'd want to see.
All right, thank you for the introduction, Ginger. So today I just kind of wanted to go over, I would say, the primary areas that I can help real estate agents with. The intention here is obviously, I represent agents, but I also represent a lot of homeowners. So it is as we call it, a power group of real estate agents and lawyers. So a few things. I'm going to go through some stuff and some stories I've seen in the past. And, if you have any questions, please let me know, and I'm happy to answer them. So first, I kind of wanted to go over, the relationship between agents and lawyers. Obviously, there's things I can't do on your end, and there's things you can't do on my end. I think we're a really good networking pair. And so if you don't already have an in with a real estate lawyer, I suggest trying to have something, have someone you can call, because sometimes the deal needs to close, and maybe there's an easement issue, something like that, where you cannot rely on these things just with title or with your own experience as agents. So I want to go over a few of those areas that it's very important to consider having a contact, a real estate lawyer that you can bounce ideas off. So first, there's the form contract. I do call it the form contract. You guys, I think, call it the residential offer and the acceptance agreement. But essentially, this just unplugged. I'm sorry. Does this matter? This thing?
No, you're okay.
Essentially that thing was drafted by attorneys, and it gets updated a little bit every now and then. But the reality of it is it's meant to check boxes, right? The problem then is when you have to start writing in things like the addendum, stuff like that. I would pose to you that you guys may want someone to look at your addendum. So for example, one story I have of a client is it was back, I would say 2 years ago, when things were just selling really fast. They wrote something, one of the agents wrote something in the addendum to extend due diligence period, but they weren't really clear on what they were saying. So due diligence lapses. One party says, no, you don't get your EMD back. The other one says, no, we extended it. I took a look at this thing, and I couldn't make heads or tails out of what was written there. It was just someone in a hurry. And now, of course, when there's money on the line, someone's going to say this, someone's going to say that. The thing I want to impart to you guys, though, as the real estate agents, if you're the one filling out that contract, you are now changing roles from real estate agent to contract drafter. And that means if there's any ambiguities or inconsistencies in that contract, that's going to be counted against you. So for example, if you didn't get it right with the EMD, that's going to come out on you. So in this event, it was so ambiguous. No one, you know, it's one of those things too, you know, if you have escrow involved and then there, you know, it's a third party, well, they'll send a complainant intervention to get the money back or do whatever they need to do. No one wins. I always say no one wins but the lawyers in those scenarios, because we're the ones who get paid while everyone's fighting. You guys may have to forgo some of your commission or something else, and not, you know, we're still getting paid. So it just doesn't really work out. So when there's that ambiguity, I always find myself advocating for splitting the baby, right? Half, you know, the EMD, if it's unclear. The problem was in this scenario, the house never sold. They were canceling. That's why they want the EMD back. So the real estate agent who had again put the hat on for contract drafter, she had to come up with half of that EMD, which was more than her commission had the property sold. Now she still was the listing agent, but she still is not going to get that money back. So what I often do, I know Ginger and I have done this before, where, you know, it's like if there's a real picky person and if there's a big sale and you're not sure what that addendum language should be, consult with an attorney. It takes me maybe 6 minutes or 10 minutes to do it. That's like 30, 40 bucks. Okay. As opposed to ruining a sale. Like I said, that one story, she was at $12,000 on that, as opposed to having someone look at it really fast. You know, so I can't stress enough that the way I would tell you guys to start is think of the most picky, horrible, whiny, dumb idiot you've ever met in your life and draft for them. And you know, because it needs to be, and especially you guys know now, I mean, is it just me or does everyone else know that people are mad right now? They're angry, they're complaining more. This is like the year of crotchety hell. I don't know what's going on, but trust me, my lawsuits I used to do maybe 2 or 3 a year. I'm up to 16 this year, and it's only May. Okay, and most of it's real estate. So it's very, very important to make sure when you are drafting those addendums or any of those kind of questions, just make sure that you get it right. The other thing, oh, I said the one that was I saw another one that was shorthand. It wasn't even full sentences. It was basically shorthand. Again, the ambiguity. Who knows what we're talking about? Luckily, no one lost any money on this, but again, the real estate agent was threatened to be sued. And you guys all know, is there anyone broker here for Fathom? Okay, don't take this personally. They don't want us to find you. No, they just don't want to be sued, right? So just do your broker a favor. Make sure everyone's on board with the language. Like I said, shorthand, it was just absolutely ridiculous. We don't want to do shorthand. The other one I saw was an easement. The addendum said parties to draft an easement later. Yeah, she knows what I'm talking about. Yeah, what was your name?
Kyla.
Kayla, what happens with that? Do they draft the easement later?
Nope.
No, they do not draft the easement later. And guess who the parties blamed? The real estate agents, because they should have known better and made sure that the clients had the easement in writing before the close of escrow. This was a driveway, by the way, and not a easement by necessity where it's the only way on. It was just the driveway was paved like 5 feet over. You know how you know the people are subdividing now. So let's say 2 family members owned a lot and they had one driveway up the middle. Now they're subdividing and the driveway's on one side but not the other side. And then they just keep selling. And then someone all of a sudden goes, that's on my property. One guy literally took a sledgehammer or jackhammer and tore up the driveway that was on his side. Because he was right. It shouldn't have been on his side. He did not give them an easement. So we have these kind of problems happening all the time. So if you guys have anything about that and the easement needs to be drafted later, no, take my card. We get that drafted and recorded. Even if the deal, I had a deal a couple weeks ago end because they didn't want to wait for this all to be worked out. They wanted to go somewhere else, but that's the way it is. Do not close escrow unless that easement is taken care of. And so we had one client, they did that. They wanted to sue the real estate agents, everyone managed to stave off World War III by drafting this easement, but it took no shortage of threatening them for 6 months, like, we're gonna sue, you can't just tear up the driveway, that kind of stuff. And then I wanted to say too, that it used to be that easements were kind of scary in the sense that we had to get a meets and bounds description. Do you guys know what that is? That, you know, we had to get a survey out there, engineered like 82 degrees to the northwest corner, and all that nonsense, okay? And good luck finding a surveyor who'll do it under for 3,000 and under 6 months, right? It takes too long. So nowadays, if the easement is drafted a particular way, that I'm legally identifying exactly what we're talking about, I can get an aerial from Google Earth and then just red Sharpie, make it nice, right? It's not red Sharpie, it's Adobe PDF. I'm not that. I'm not that silly. Anyways, but you know, we did a red line. This is where the easement is. Then we go out, we mark it, and then we're good. So the fastest one I did was 3 days from problem, drafting, recordation. Because that's, you know, I know property moves very, very fast. And so in my practice, usually put real estate matters absolutely at the forefront because I don't want to ruin deals. But that is how fast it can take, but never, ever, ever, ever say they will draft it later. Same thing with maintenance agreement. So maybe they don't know they own the road, but who's going to pay for it? Who's going to do the snow shoveling? I had a guy again subdividing out there, and it's on the way to Carson City. These landlocked areas, you know, there was little easements to get to the landlocked area, and this this was done in the 80s. No one said that how the easement had to be. Everyone's assuming it's going to be a dirt road, but then farmer behind subdivides his 10-acre parcel, 1 acre each. Now he wants to put 10 homes up on there. Well, guess what happened to my client now is having zoom on this little dirt road 5 feet from their house. And the guy wants to now pave it and do all this stuff, which makes sense because paving, if you have that much traffic, you should pave it. But the problem was my client wants to ride his little horsies down that way, and horsies don't like asphalt apparently. Making worse something new every day. But so I mean, these are the problems with badly drafted easements. So for example, if you're working with someone, like I said, there's a lot of subdivision happening where easements are now becoming a hot, subdividing of big parcels, landlocked parcels. Easements are becoming a problem. It isn't enough. I'm just letting you guys know the way the laws work. It is enough to tell your client, yeah, there's an easement there. It's not enough. We have to know what the easement says. Who takes care of it? Do they get to pave it? Do they give it a fence up? How fast can they drive? All these things have to be in the easements these days. It used to be, if you look at old easements from even 15 years ago, it just says, yeah, you have an easement, left side of my property. It has to be so much more particular right now. So I highly encourage you guys, and this is not a burden you guys should bear, right? It's what you then tell your clients, hey, you need to have a lawyer look at this. And that lawyer needs to tell them exactly what's going on, because then at that point, if the lawyer biffs it, you guys are not on the hook for it. It's the lawyer's malpractice insurance. So again, I always believe in shifting liability to where the liability belongs. Sorry, I haphazard wrote notes. Okay, the other one I saw on one of the forums, I thought this was it was a very expensive piece of property, multi-million-dollar piece of property. And the listing agent did not mark the damages clause. So we all know about liquidated damages and actual damages, okay? And no one checked anything, but everyone's so used to liquidated damages. Like if you pass your due diligence and you cancel, the EMD's money, kind of a thing, right? And that's kind of clear cut if we mark the books. The problem was someone had I can't remember. I always used to tell you all the bad places in town, where I can't remember who did this one. There, you guys can play with those PDFs, not that you should, but you can technically download it. And so I don't know what they did. They were formatting it, and it closed the box where then there was nothing to check, nowhere to initial. No one sees it. Now we're fighting over an $85,000 EMD And it had gone to the agents, the brokers, even the other lawyer. And I finally was looking at it one day. I'm like, I always go for the default or the damages box first. I'm like, here's the check. It wasn't there. Check wasn't there. No one checked it. No one signed it. And it was a trump. At that point, my client got their $85,000 back, even though it was after due diligence because no one had checked the boxes. So I can't stress enough to where, especially in your guys' profession, you guys, it's rote, right? You know, you see it day in, day out. It's the same thing day in, day out. It doesn't mean to not slow down and make sure that everything is on the up and up. Because again, I cannot tell you enough that when the poop hits the fan, you are their first attack. Then they go to your broker. And then then they go to the seller or the buyer. I mean, I'm telling you, you guys are the first line of defense and who's going to take the first blow. So be very careful with those agreements and contracts and make sure that you are understanding what the client needs and what the client wants, and do not try to be their everything in terms of those documents. There's things like, I work in a lot of escrow companies in town. I do their deeds of trust and promissory notes, you know, and my main competitor churns out the same document every single time. We're not competitors. She's the only one who does it too, but you know what I mean. It's the same documents all the time, but it doesn't fit the deal. And you know what? It goes to record, and it's not right. You know, and so again, that's going to come back on you guys if you don't make that introduction to, I would say, a real estate attorney. So for example, I have a lot of clients in town, real estate agents, where they have a problem and they just introduce me to the client. And now the client and I have this relationship. Client's paying me, we have confidentiality. Of course, I include the agents all the time in these conversations, but the point is that if something goes wrong, it's now not on you, it's on me. Did I do the deed of trust wrong? Did I do the promissory note wrong? Did I do the easement wrong? If that ever happened, then that's when they're coming to me and not you. I just want to be very clear that at the speed you guys were going for the last 5 years or so, there was a lot of things where agents were putting on different hats that they shouldn't have. And I'm a very stay in your wheelhouse type of person. And I cannot emphasize to you enough the favor you're actually doing to your clients by introducing them to the real estate lawyer to make sure that those parties that are on top of things and getting things done. And then you guys don't have to worry about it. You don't have to worry about the paperwork, only the paperwork you have. And then it helps out a lot. The next thing I want to talk to you guys, any questions on that so far? The next thing I wanted to talk to you guys was about, can I grab this chair?
Yeah. Do you want the table too?
Yeah. So essentially you've heard, I would say my number one reason I'm working with real estate agents is I'm helping them form their LLCs like I did with Christy. Now there are two reasons in your profession to form an LLC. One is a tax savings. And you guys, I'm sure you guys all know this or heard about the Forbes. So I apologize if it's repeat, but essentially the magic number is about 120, 130,000 a year net. If you are making more than that, you want an LLC to be taxed as an S Corp to limit Social Security, Medicare, that kind of stuff. So they're the great tax reason. Even I do it. I save probably about 15 grand a year on this. It's great. It's why I pay more taxes if you don't have to. Because if you're a sole proprietor and you're making 140,000, it's coming right to you. You're paying taxes on 140,000. If you're an LLC tax as S Corp, you can say your salary is 80,000. You're only paying Social Security and Medicare on 80,000. LLC is paying for the whole 140, but it's a huge savings in taxes. Now I know that's the main reason a lot of real estate agents do the LLC. The other reason is liability protection. I am a firm believer in anyone offering professional services, you're going to come across someone who wants to sue you because they don't think you did your job right. So what the LLC does is it say, well, it's not me that did it, it's the LLC that did it, because now if they sue you, they're suing the LLC and all of its assets, which is usually, like in your profession, it's probably your car and your bank account, if that, right? And some signage. As opposed to suing you, which is your nice house, your vehicles, your kids' braces, whatever. Okay. Now, the one thing that your profession, I think, has a little bit of a kink, and maybe it'll change, but I don't like it, but it's basically saying, if you're going to be an LLC and your LLC name is on your contracts, your LLC name has to be your name. That's the rules of your profession. They want your name as whatever your name, LLC. and now you can put it on your contracts. Now, if you have a different LLC name, then, something like Dream Real Estate LLC. Dream Real Estate LLC is not the license holder, the real estate license. So when you go to contract, you have to put your name on it, and it doesn't have your LLC on it. So for people who want ultimate liability protection, you're going to have, in your profession, you're going to have your name, comma LLC, and ask your licensing board to associate your license with that LLC. And now your LLC name is on that contract. The reason I like that, I know that's not how everyone does it, is because, again, on those things where I told you that the agent had to pay $12,000 for the EMD, if she got sued for the whole $24,000, they'd be suing her LLC, not her house, or her kids' tuition, all kind of stuff. So I like to keep that separate, but I know it's a kind of pain in that. But I know that even if you don't have your contracts with your LLC name, I know your brokers usually that's who they pay, and that's still fine. But that's a tax savings only. I want to be very clear. If your LLC is not on the contract, you are not utilizing that LLC for its full liability protection. The next thing I want to talk to you about is trust and estates, because again, I do business law, real estate law, and trust and estates. Trust and estates is.
I have a quick question before we move on from this. Something that I get asked a lot, Heather, is like, what's the difference between a single member LLC and a regular LLC? I always tell them you need to go talk to your attorney or your CPA, but can you talk about the liability when you're doing a single member LLC on Schedule C versus the 1120S?
Good question. It's actually the same liability protection. So single member LLC is when there's one person, or it's a husband and wife, or wife, husband, legally married in the state of Nevada, or community property state, is a single member LLC. Same liability protection, different taxing. So it goes on your Schedule C, on your 1040. They're single members, that's one person or a married couple, and then a multi-member. Multi-member just means more than one person or two people who aren't married, and they get taxed on partnership returns. So again, yeah, that's a CPA distinction or tax distinction. Liability-wise, there's no difference, so it won't matter. The only thing I will say is that liability-wise, with a single member LLC, it's a little easier to say they don't have corporate formalities. Have you guys heard of piercing the corporate veil? So basically, you can have your liability protection unless you're using that thing like just a veil and not a real wall. Like, for example, if you use your business credit card to take your kids to Disneyland or something like that and call it a business expense, and you're just moving money back and forth and there's no record of it, they're going to say as a single member LLC that you are using your LLC wrong, and they will pierce the corporate veil. And so there is, if you're a single member LLC, if you don't follow the rules, don't keep things separate, there's a greater chance of losing your liability protection. I will say though, I found this is a couple of years ago, I used to always do member managed LLCs when we're by ourselves, just us. But there's been case law recently that is saying if you're a manager managed LLC, it has this authority of separation. So even if it's just you, so now I'm forming all my LLCs manager managed to be one more step removed. It is a fake line of distinction, but when I see the courts going that way, I kind of just want to keep up on that. Okay, so when it comes to the trust, like I said, I actually had a specialized degree in tax and estate planning when I was in law school. It just turned out that that's not obviously where I ended up. So I've known how to do trust and estates and tax and stuff for a long, long time. It wasn't until I became a business lawyer that I realized my business owners were not taking care of that part of their life. They did all this stuff to build. They did all their contracts are right. They still consult me before they fire or hire anyone, and they don't have a trust. And so what happens to that business is the minute you die, any of you have an LLC right now, and you don't have a trust, the minute you die, even your broker does not have to pay your loved ones. It technically goes to your estate, and then they have to show their, of your community property, that's one thing, but like, your parents, your kids, stuff like that. Technically, brokers have to be careful who they pay out to, or you're not entitled to your last commissions, or even if you say you have all your commissions and you got $100,000 sitting in the bank, your spouse, even your spouse, cannot get to it if you have an LLC but don't have the estate planning. I just want to be very clear about that because it breaks my heart when everyone has all that stuff figured out. And it's usually the husband, actually we're all of us but one are women here, so unless you want to change for the day. Is that it happens more, so this is not in our scenarios, but a lot of times it's the man who is all the business, woman's doing whatever she wants, husband kills over with a heart attack, all the money to pay their day-to-day is sitting in that business bank account and she can't get to it. It happens every day and it drives me absolutely crazy because it's so easy to fix. And a lot of people do have trusts. So one, you got to get the trust, because the reality is they've changed Nevada law so much in the last couple of years that if you own a home here, you are not escaping probate. If you don't have a trust and you own a home, you're not escaping probate whatsoever. Even a bank account, you're not escaping probate. And that is probate value is 3 to 4% of your estate value is what you'll end up paying the probate attorney, as opposed to buying a trust. Now, I know there are different prices in town. I feel I'm a very competitive price because I have a lot of my business coming elsewhere. But for a single person right now, flat rate $1,500, for a couple, flat rate $1,900. That's way cheaper than a probate.
So if you're married, when you're not married, you're together.
I still call it a couple trust. Yeah. And you can do that in Nevada. I do joint trust all the time. I actually do something a little separate just to go on that little path because, and I feel like this way every marriage, but a lot of the men get offended at this. Sorry, picking on you. No, because I like what's called a joint reciprocal trust for a couple together, because what happens is it's two standalone trusts. They're really what people use in non-community property states. Joint, because if you don't have community property, then everyone has their own property. It's not joint, right? So it's joint reciprocal trust where each party has their own trust, but it pours over into the other one if they stay together. If they break up, separate trust just change your beneficiary. It's a really good deal, I think, for people who are coupled together but they just don't want to get married. And I always say the same thing though, if you're married, but again, it doesn't pass with a lot of people. That's okay. It's out there. I throw that out there for them. But the reality of it is that having the trust, like I said, no one's getting out of Washington, I would say Nevada, and this is true for California too. I'm licensed there, by the way, as well. It is that you're not getting out of those states without having a trust or paying a bunch of money in probate. So one of the things that you can look when you're doing your sales or listing, or if you're the buyer's agent, is it who was the offerer? If it's just a regular person or a couple, go, well, do you have trust? And if they don't have a trust, you might want to push them to see an estate planner, because again, our homes, I think this is especially true for this area, our homes are our number one asset for almost anybody. And if they don't have a trust, their number one asset is going to be hauled into probate. Who's paying the mortgage, stuff like that. So I love to do the trust for that to make sure everyone's good. But again, on the business side of things, what happens is again, if you've passed away, your LLC now is left without a captain. There's no one steering the ship. The banks will lock your accounts down right away. And the only way to avoid that is if your LLC, you have an LLC, and your LLC is assigned into your trust. If your LLC is assigned into your trust, now you've passed away, but your trustee comes in and says, no, I'm the owner because it was assigned into it. And now they can get into the account. They can close out all, collect whatever commission checks you have, pay the bills, and take money out of the bank account. Without that, you're looking at either fraud to get your money out, or you're looking at 6 months to a year to be able to get access to that money. And if that's your main, and I know people, especially single member LLC people, will leave all their money in their business bank account and they just take what they need. So that means that most of your money is sitting here and you passed away, then who's going to pay the bills? How are they going to get the money to pay the bills? It's a very unfortunate event. The next thing with your clients and trust is, what if it's two people cohabitating together? And this is especially true of older people who are on their second, third, whatever marriage, and they just don't want to get married anymore, but they love each other, they want to live together. Guess what happens when one of them dies? You aren't married to my dad, get out. I swear to God, that happens all the time. They are entitled to, if there are two people cohabit, the joint tenancy, we know that the joint tenant gets the whole thing. That doesn't stop the accusations and the lawsuits. And so I always say the best way to protect that is not just to have the joint tenancy on the deed, it's to have a trust that says, you know, yeah, it goes to her or it goes to him, or they get a life estate and then it goes to you. For example, I know a lot of people, one person's on the title and but they want their other spouse to live there until the end of their days. Okay, but if they haven't put it in a trust, those kids is over. They come right in, they get the house. They just get the house because he or she was not on the deed. So there's a lot of problems happening again with the rates, or I'm sorry, prices are as high as they are in this area. When you have one person pass away, the wolves will come out. And as I highly recommend being suggesting to your clients to be put in or to have get their trust done, or if they have a business, to make sure that their business gets into the trust. And yes,
You put stuff in like health direction, that sort of thing, and somebody gets sick or dies, or they get in the hospital.
yeah, my trust, that's a great question. My trust include your main trust, and then a pour over will, then your healthcare directive, your power of attorney, any assignments you need, the deed to your primary residence, and actually Christy is my notary, she's my favorite. So I notarize between Christy and myself, you know, and that kind of stuff. So yes, it's all in there. There's
What about if somebody dies, on the seller side for us,
Mhm.
where they're still on the deed and the assessor, do you help take those off? Whether the process, I know it's hopefully a trust, but when it's on the,
So, not the assessor,
listed.
yeah, I know what you mean. The assessor site is slow, yes. Hopefully, that's another reason to push the trust on your clients, because then it's so much easier, because the trust owner is the title owner and they haven't died, so nothing's changed. But yes, are you talking about like an affidavit, death of joint tenant, that kind of stuff?
yeah, just be able to list it sometimes if they have to go
Yes.
through their attorney, and I don't know who that is, I can push them your way instead.
I would love that, because like I say, usually, well, my clients, they have that stuff done with me first before they find an agent. But I know, but that's just because we've had a relationship for years. But yes, the ones who just come to you and say, I want to list my house, so and so is dead. The first question is, I always tell you, did you ever file an affidavit, death of joint tenant? And they say no, push them to an attorney, because it is a very particular, obviously, document. And yeah, I get those done pretty fast, as long as the seller is willing to sign really quick. And I need a death certificate. Sometimes that's a hold up. But yes, absolutely. All that stuff that you guys need to close a deal when it comes to recording, that kind of stuff, that's what I love to do and take care of. The recorder's office obviously is very familiar with me. We get things done. I love e-filing now. It's great. But yes, anything like that needs to be done. And now if they have a trust, they still need an affidavit death of trustee. So if they don't have a trust, if they need an affidavit of death of joint tenant, if they do have a trust, they need an affidavit death of trustee. And the last thing they need, which is more of a new thing, is all the trusts need a certification of trust. That's what, for example, if you have a buyer who wants to buy in the name of their trust, not you, but usually escrow, or you ask, can I see proof of trust, the certificate of trust, whatever it's called. And that's how you guys use or give to escrow. That's how they title it, right? The problem is that, you know, say the wife has survived, the husband has passed away, she still has her certificate of trust from like years and years ago. Guess what that thing said? You better get dead husband's signature to sell this house. Well, obviously you're not going to get a signature. So they need an affidavit death of trustee, because the trust still is the title owner, but the certificate says you need both signatures. And that's when I then do the affidavit death of trustee, saying, no, he is dead, you only need her signature, or vice versa. So there's a lot going on. And as you guys know, when someone has passed away and that kind of stuff. And then there's also the last thing I do on that is, if they didn't have a trust or will, I would refer it out. But if they had a trust, but they forgot to put the house in. And as you guys know, nowadays, when you want to refinance, they make you push it out of the trust, and then they give you your deed back with your names on not in your trust anymore. And some people forget to roll it back in. If that happens, I also do, it's called a motion in probate court, motion to set aside or confirm trust asset, that they meant to put it in the trust. And I do that motion in front of the probate commissioner. It says, you know, they meant to put it in the trust, it just happened that they didn't, and we roll it over into the trust. And that goes with bank accounts, cars, definitely the houses, anything that the person forgot to put in their trust. So that I can help you with. If it's a full-on probate, I do refer out to someone who only handles probate.
What if it's a will?
And so that also goes to probate, so trust only. And wills, I gotta be honest with you guys, if you have, if someone says they have a will, tell them to go talk to an attorney. I personally, there's a lot of attorneys in town who agree with me, any attorney who's only drafting a will could be liable for malpractice, because it isn't enough.
And they think it is, that's why.
Yeah, they pull it off, yeah, they pull it offline. A will is still gonna go to probate, it's still gonna cost a 3 to 4%. It's completely worthless without a trust.
And how often should you redo it?
The
Your
trust?
Like,
So I say there's 4 times, okay, 4 mandatory. 1, divorce or marriage. 2, leaving the state, going to a different state. And I don't care where you go, unless it's you go from non-community property, I'm sorry, community property, non-community property, you do not have to redo the thing. So I always tell people, you move, shop around for an attorney who's just gonna change the state, not the whole thing. Like, for example, you can imagine the people we get from California. I have lawyers in town who tell them they need a whole new trust. Like, no, I'm find and replace California, Nevada, you're done. Okay, so I said, just if you have people coming in from different state, do tell them they don't have to redo the whole thing. You know, so getting married, divorced, leaving the state or coming into the state, so change of residence. 3, changing your trustees, so the people who take over after you, and then 4, beneficiaries who inherits after you. You know, so if you want any of those changed, you have to get an amendment to your trust. Everything else is assets in, assets out, and it doesn't need a lawyer. And I do get asked questions on how to do certain things, but you don't need to change the trust for those things. Assets in, assets out, just like anything else. And when the updates, if there is there hasn't been in a very, very, very long time, but if there is a huge update, I have all my clients on CRM and I would blast them and let them know it's time to change things.
That's probably the next question, but I said trustee and beneficiary.
Mhm.
What's
So the trustee is like an executor in the will. It's the person. So when, like, for example, I have a trust and right now I'm the trustee of my trust while I'm alive. When I pass away, or my husband and I pass away, then the person to manage the trust is going to be our son. But so they're trustees. They're basically the admin, they're everything. They have the fiduciary duty. They can sell property, buy property, put money in the bank, take money out. So they're basically the runners, executors of the trust. And I hear that also, people say executor, trustee, it's the same thing. I just let them have their words, it's fine. And then beneficiaries, who gets your stuff. Like, for example, my children are the beneficiary of my trust. And when they have children, it'll be them too, you know, kind of a thing. So the beneficiaries who benefits from your assets.
so if your kid's 13, not able to do that, and I die,
Mhm.
and I have trust, would it go to somebody else, put it in his name for now until he's a certain age?
Yeah, so right now, if you do nothing, there's this uniform minors act, something like that. You don't want that because it goes into a locked bank account. There's so much court proceedings, and then someone's appointed to look after the money, and I don't think it's safe. For example, I have heard many, many times, so Junior needs braces and the person gets a boob job with the brace money. I mean, honest to God, this happens all the time. I swear to God. Or one time, he said his kid needed college, whatever, and he bought himself a new Bronco. I mean, so there's a lot of, yeah. So with the trust, if you have a 13-year-old, then you have to pick a guardian for your child until they reach 18. That person then is also a trustee and a guardian. So trustee again manages the trust, guardian manages the child, for lack of a better way to put it. I always say make those people 2 different people, because then the guardian has to ask this person for the money, and this person is usually a little bit more removed from it. And I also put in all my trusts that unless someone is just really, really trusting, I'm sorry, I don't trust a lot of people. Where I say that the trustee is paying, like for braces, trustee's not giving you $5,000 for the braces. Trustee's giving orthodontist $5,000 for the braces. And that really eliminates, when I put stuff in like that, they're not wanting to mess around because they know they're going to get caught. So yeah. And then, so for example, in my case, I think my kids were 13 and 8 when I did my trust. And now And I had my mom, she was gonna be their guardian and someone else is gonna be the, you know, but now that I have a 21-year-old, guess what? I'm like, you are taking care of your brother and Angie still gets to take care of the money, you know, it's just, so you can do all sorts of things with that, but yes, you cannot give, you can't give it to a 13-year-old. What it does is, it's up to you, but I usually stagger mine 25, 30, 35. And that's when they get their money, like a third. And you can do it. The beauty of a trust is that you can do it like that. Whereas that if you died without that, your 13-year-old would get that on his or her 18th birthday. You know, so, and then God, you know what people do when they're 18. So that's all I have. You guys have any questions?
So I have a house,
Mhm.
right, and if I die. It's just gonna go to the government and I don't want it, so I should just do a trust for like a friend or something.
Yeah, well, and then right now it wouldn't go to the government, it would go to your heirs. If you don't have a trust, it goes to your heirs at law, which is,
So there is nobody in
No.
this country, not by law, not by blood.
even in a different country, they'll try to get a hold of your relatives in other countries. So yes, in your case, it probably would go to the government eventually, because they're not gonna really try. So yes, what you would do is, I have lots of clients who all by themselves, never married, no kid, and they pick a charity. And so, or a friend who's helped them, and they get the house, or the house gets sold and they get the proceeds. But yes, this way you are going to decide where your stuff goes. Like, for example, I would say the number one concern I have from single people is that they hate their parents, or they hate their sister, whatever it is, they hate, you know, I hear a lot of a lot of family woes. They just think, oh, yeah, everyone's a jerk, I get it. No, but their biggest concern is that if they were to die, their sister, who they haven't spoken to in 25 years, would get all their stuff, because that was their only living relative. So they do the trust specifically to say, no, I want so-and-so to get it, and I'm specifically disinheriting you. Because like I said, if you die with heirs in law, it goes even to like fourth cousins removed. You might actually have relatives in this country that you don't know about, and it would go to them. This happens all the time. You know, I'm just saying that, but you have a trust and you're taking that uncertainty out of it. You know exactly where it's going to go.
So I would make a friend a trustee and a beneficiary?
You could, yes. Yeah. And that's easy, because if you're the trustee and beneficiary, you're just giving it to yourself, and it's really easy.
And then for like godparents, is that a thing you trust still?
You can call them that way, you just call them guardians, but yeah.
Guardians,
Yeah.
it's the same thing.
Yeah, I mean, like I said, my kids are grown now, but when they were little, I specifically said that their guardian had to move into our house and stay there until the last one graduated from high school, and now they have to do it. If you don't write that, and then they can move them God knows where. I just think it's best not to upset them on those crucial years anyways, you know, so they've just lost their parents. So I just, like I said, I don't see the downside to trust, or I'm sorry. And now I'm telling you, it really has to be. There's, I don't know if you guys have heard bank accounts, you know, if you are, let's say I'll use Ginger's parents. So let's say Ginger's parents didn't have the trust, and they put Ginger as the payable upon death of their bank account. And so she thinks, well, good. Okay, well, I get paid on their deaths. And so they passed away. So I want to go get the money. She walks into the bank and tell her, no, get a probate order. But with a trust, if you have the bank account, and do they have that in the trust name?
No, I have to do that.
Okay, you get on that. Especially Wells Fargo, Chase, and US Bank. I don't care if you have the trust as the payable upon death, they're gonna make you get a probate order. Is your bank does this too?
No, we're a little bit easier
Okay.
to deal with. If we have the POD on there, typically it's just waiting on the death certificate.
Yeah.
We go to legal,
Mhm.
they usually clear, it. There's an affidavit that gets
Yes.
signed, that kind of releases our liability. And then we're able to exit out, but in the meantime, you notified me that so-and-so died. Everything's getting locked down,
down.
cards canceled. I don't know how you're gonna make your
Yeah.
payment.
So Nevada State Bank, good. Okay. No, but that's the way the law works. I'm sorry, the law is very clear on this. It says if you have a trust, or, you know, and you name so-and-so, you're payable upon death on your account, they should be able to take the death certificate and get the money. But Wells, Chase, USB, and we're getting more and more every day saying, no, because there's a private business. They don't default, they can do their own policies and procedures. So now I'm saying the trust, whatever your trust name, actually needs to be on the left-hand corner of your checks on the bank account. Because no bank can then deny you to give you the money then. And so, because like things are, at COVID, we had a lot of fraud. People just said they make their own certificate of trust. They're making, I'm sorry, I know this is a nightmare for you.
Yes, it is. I'm like, please don't tell me you Googled it.
They were making fraudulent certificates of trust, and banks were paying out, then the real heirs came, it was a nightmare. So that's where now they are not paying out upon death at all. Or I'm sorry, certain banks, NSB is a good one, but I just saying be prepared for what's coming down the road, and that's all of the bank accounts need to be in the name of the trust to make sure that the people, the trustee and the beneficiaries have access to that money.
And it's pretty simple too. I can't speak for every financial institution, but if you're looking to change from your personal name into the trust name, typically what we just ask for is a copy of the trust. And when we say we want a copy, typically, as of late, we've been asking for the whole thing. And that's so we have it on record for your protection for when you die. So it's a little lengthy at start, but once we have it and we put it in there, we just draw up a new signature card, you sign however you sign, and it's done. You get new checks ordered, and it's really not too bad of a process. The biggest thing I get is, why do I have to give you the whole track?
Yeah, that's true, because I tell them you only need a certificate, but yeah, but that's my point, is that banks have every right as private businesses to make their own rules. And I'm just saying the easiest way now is to have a trust and the whole trust and to get it taken care of. You guys should expect more, like I think, well, this is a while ago, I was talking about the deed upon deaths. It used to be, even 5 years ago, if I had a little lady who had nothing but the house, you know, I'd give her deed upon death to her son or whatever it is. We could avoid probate. Not anymore. Because again, same thing, fraud. Even if you get the deed upon death, how many, you know, that's like 36 months. You guys know, escrow tells me. Again, it's an escrow rule. It's not a legal rule. So depending on the escrow and title company you're working with, they can say, no, we won't insure this. We won't title this for, you waited 3 years. Well, who's paying the mortgage for 3 years? The son or daughter just wants to inherit, flip it. They can't. Or they'll tell you to go to probate. So again, now you're paying more money than had you just done the trust in the first place. So keep an eye out for, I know this sounds stereotypical, but little old ladies. Keep an eye out for little men. Keep an eye out for people, older people cohabitating or younger cohabitating. Actually, I'm sorry. That's my biggest thing right now. Sorry, I'm getting so many calls. I've got to turn it away. Couples in the good market who bought and they've now broke up and they want to split up. But you know, no one can refinance right now because the rate's going from 2 to whatever it is. So there's a fight. So, and my thing is, if they just come to a lawyer, the couple before, and had an agreement of this is what happens with the house if we are to split up. So keep an eye out for cohabitating couples and, you know, see, make sure they have an agreement on, you know, who gets the house if they split up. I can, but who gets the dog? and you know, who gets all that stuff, because we actually we had an agreement. This is up in Tahoe where after they split up, that this is not my agreement because I usually try to cover all the loopholes, that once they split up, so the woman kept the house, but she had to refinance within 18 months. She could not qualify when they got the mortgage all those years ago. It's fine. She can't qualify now. So what is she supposed to do? So she ended up having to sell the house. It was a shame because who wants to sell out in Tahoe, right? You know, you could leave it forever. But so think about those things. You see those kind of clients before you just jump in with them and here's your house, congratulations, and give them their candle for closing. Is make sure that they are prepared to go. I can even do with a married couple. I draft premarital agreements, I draft post-nuptial agreements, I do all that stuff because again, the houses that you guys are dealing with are the biggest asset by far that anyone else has. And so when they're going into these, they're just thinking about, well, closing escrow, great, I'm gonna make my mortgage payment, but there's so much more. There's so much more to it. So I would covet your referrals. Like I said, the real estate part of my practice is my favorite part of my practice. I do also do a lot of commercial. If you guys know any commercial real estate agents, I do all the CC&Rs, I do all the county variances that they need, I do leases, I do all that fun jazz, and even the agreements for tenant improvements, that kind of stuff. So any of your real estate needs, I can help you.
How much do you charge for the consultation?
I do a 30-minute free consultation for certain matters, It's only on the phone now these days.
Okay.
And then my rates are $300 an hour for now. I'm trying to keep them steady this year. Everything else has gone up, trying to keep it steady, so I can't guarantee that for next year.
Okay,
Yes.
so did you say, if I understood right, the LLC, like for the realtors, that it should be under your name, not under your business name?
It doesn't have to be. It's your licensing board says, if you want to plug your license with the LLC and your name have to match.
We might fathom they maybe change it.
Yeah,
to
yes.
within our
yes.
coverage too.
So you can have your, I have clients who have they want that LLC with whatever name they have, which is fine. It just, your license number won't attach to it. Yeah.
So then would you do
Attached
a,
to it.
Not if it's not in your name, no. It has to be your name, come LLC, and then the license will attach to it.
So even if you start a business.
so then would you do a DBA, with the, like, file a DBA?
You have to ask your license. I know the other professions you have to ask your license. I've never asked that. Jender's shaking her head no. Yeah, see, it's your particular licensing board that makes these rules. Any other business, fine. Yeah, like even the same thing with mine. Like when we're talking about LLCs and trusts, there's no way I can put my LLC. I'm sorry, yeah, I cannot put my LLC into my trust because my state bar has said the trust isn't licensed, only Heather's licensed. So you gotta just listen to what your state licensing requirements are. But my thing for you, like you, is you decide what you want. If you just want the S Corp tax savings, I don't care what your LLC name is, don't worry about it. But your name is on that contract, and if you make a boo-boo, that all of your stuff, you know, I know you have errors and emissions insurance, but you know, wherever your house, all that stuff is on the line if it's a big boo-boo. And so again, not my choice, but I'm just saying the best liability protection is your name LLC, license number, and that's what goes on the contract.
And then when you said, only for tax purposes for the, LLC to be taxed under S Corp is over 130,000 if you're.
It's, don't hold me to it, but
But just-
yeah, I've heard accountants say
That's-
120, I've heard them say 140, so I kind of just, straddle in the middle.
Perfect.
And if you already had an LLC, but it lapsed, how do you go about? Do you just
It's
contact the-
cheaper to restart it.
Oh, really?
If you let it, so if you dissolve it and
Mhm.
paid the 110 fee, you can revive it, no problem. If you've let it lapse, every year you let it lapse, there's late fees, penalties, and the 350 a year. It's literally cheaper to just restart it.
And how much would that cost for you to do something like that?
For me to form an LLC, it's 300, or actually right now it's 390, because we have to do that federal reporting requirement, so it's 390 for that. And then the filing fee, I want to say is like 436 for the filing fee, and it's just a flat rate. I put myself as your registered agent. So if anyone wants to send you something threatening, it goes to my office first. And then I remind you that it's needs time to renew every single year.
So it's better to redo it than if I.
100%, I would not pay those fees. And if you want to use the same name, we can always make a petition to the state. I do this with some of my clients. Sometimes they say no, sometimes they say yes. Most of the time they're asleep at the wheel and they just let it pass anyways. So the same name, but you might get in, well, like I said, if that comes to it, we can discuss what it is, but usually the best way is to figure out a new name and then move forward.
And then the trust, at what point do you want to do the trust? Just that, like, asset wise, like, where do you want to do
No.
the trust?
Yeah, even a bank account, yeah, because you can't, like I said, if you just have a bank account to your name, and that's all you have, you're renting and you own your car, watching your car is another issue. If you, let's just say you just had a bank account, you take the bus and you rent, your heirs cannot get into that bank account unless they go through probate first. And so the trust is just something I think and this is in Washoe County. Everyone in Washoe County needs a trust.
And what did you say the fee would be for?
A single person is 15 and for two, it is 19. All right, that's all I have for you guys. Any other questions?
Just real quick,
Yeah.
so if all your accounts like checking, savings, and both you and your wife's name, that's fine. It's just that we both died together,
Yes,
then that's where it goes goes into.
A great question, sorry.
Trust.
Yeah, because I have a lot of married couples who are like, well, why do we need to? If I die, who gets everything?
Yeah.
Yes, it's when so what happens on simultaneous death?
Okay,
And then unfortunately, it's just not something the widow thinks about.
yeah,
And then they end up dying too, and then it's a mess, yeah.
okay.
But yeah, married couples, everything goes to the surviving spouse. These things are only for when you're the last person standing.
Okay.
So my husband have house, it's his name.
Mhm.
Before we get married, he bought house. I already have a house and we got married. Both house don't have each other's name. So that's still go to probate?
Yeah,
Okay,
yeah, especially because there's no joint tenant.
yeah.
And you gotta be careful, another thing I do too is if people have like that, they separate property, get married together, I always put a post-nuptial agreement in my trust that says, even if you retitled everything in the name of trust, your property is still your property and his property is still his property, so we don't commingle it.
So like even make one trust.
No, yeah, one trust, yeah. One trust with a marital agreement.
I see.
People do that with businesses a lot too.
Yes, that's another thing too, business, people are not, they're being too trusting. If you know anyone starting a business with a
My
market,
friend's been married like 4 times already and she has a business.
well, then let's
She
talk.
doesn't agree that
You're right. You're my heart.
I
I don't do family law, I don't do divorce, I'm telling you, those business divorces are horrible. And especially when you bring in a spouse, I mean, at least I do all that stuff to protect the businesses. All right, well, thank you.